Hey, good morning, everybody. It's 9 o'clock. We're going to give another minute or so just to let everybody get admitted, and then Bailey and I will get going. All right. Good morning, everybody. It's 9:02. I think the admissions have slowed down a bit, so we'll go ahead and get started. Welcome to our Burr Morning Show. Thanks, everybody, for joining us this morning. I'm Bryance Metheny. I'm the chair of the Labor and Employment Practice Group here at Burr and Forman, and have talked with most of you a number of times about various topics that have arisen over the years. With me this morning is our newest associate, Bailey Wood, who is actually making his debut on the Burr and Forman Morning Show. So let's all treat Bailey nicely. This topic that we're going to be talking about this morning, L&E and the next administration, is one that I'm old enough to have delivered, 4 or 5 times about new administrations with completely different predictions and expectations every time. But I've kept statistics and I've been exactly 100% right every time. So you know that you're in good hands with me and Bailey this morning. We're about 3 days away from an inauguration that's going to change the landscape of both labor, traditional labor, and employment law. The question that remains for all of us is not whether things will change, but how, to what extent, in what direction. It's not as easy to predict as it's been with recent administrations. So as we get into the topic this morning, I just want to remind everybody about the Q&A feature. If you have questions about anything that we say that you would like to have answered during this presentation, type them in the Q&A or the chat. We'll pay attention to it and we'll try to answer those questions as we go. If you would like to talk to us after the presentation ends and have a little bit more of a substantive conversation that you'd like to have, feel free to call either one of us. We're happy to talk through some of these issues with you, but we'll do the best that we can to answer the questions as they come up during the presentation. Our plan this morning is to, frankly, just do a whole lot of speculation and guessing. Because the simple truth is that not very many people have a real good sense what's going to happen with this new administration. This administration is really likely to be, it's a nice way to put it. I guess very non-traditional would be the best way that you could describe it. We can often make predictions as lawyers based on our experience and what's happened before that are perfectly accurate just based on the party that won the election. That's not necessarily the case here. What we have more than anything is a populist administration that really doesn't feel burdened by traditional party platforms or norms or historical precedent that's been set. For example, the nominee for health secretary has a history as a very outspoken abortion rights advocate, non-traditional. That's not exactly what you'd expect from a Republican president-elect. The nominee for intelligence is a Democrat. Just certainly not what you'd expect from a Republican president-elect. But most relevant to our conversation this morning is that the nominee for labor secretary is the most pro-union Republican in America right now. So nothing's normal. All bets, to some extent, are off. So what Bailey and I plan to do is to go over the changes that we saw under the Biden administration that most directly, impacted how employers, especially, folks that are on this call, HR directors, in-house counsel for those employers, manage the workforce. And then we're going to attempt to predict what's going to be different about those efforts for the next 4 years. So to start, as I've already mentioned, this is going to be a little bit different. And in fact, we believe it's going to be different even than Trump's first 4 years. That seems apparent already. The labor secretary appointment illustrates two pretty important distinctions that I see with this Trump administration. The first is that he's more prepared to put his own personal stamp on the way this administration governs. In 2017, Donald Trump was simply not prepared to be president. Like everyone else, he was very surprised that he won. So his initial nominees to the most important roles in almost every way were very establishment because he simply wasn't prepared for that particular aspect. And it indicated that most recommendations that he received and accepted 8 years ago now were from regular Republicans who wanted to govern as conservatives. You take, for example, the difference between his appointment of Peter Robb as general counsel for the National Labor Relations Board in 2017, his first term, and contrast that with his labor secretary nominee this time. Peter Robb's an establishment, old school lawyer who represented employers and had a reputation as a union buster. Most people believed that he would, and he in fact did, take the board in a very pro-business direction that sought to fundamentally change the way the National Labor Relations Act was interpreted and administered. The nominated labor secretary, Lori Chavez Derrimer, is a very vocal union supporter, even though she's a Republican. She was a Republican who supported President Biden's PRO Act, which we did a number of presentations about 4 years ago. This is the most union-friendly piece of legislation that any president has ever genuinely attempted to pass. Our labor secretary nominee supported that bill. So the question, I think, for all of us as we talk about these issues today is why? Why did President Trump, President-elect Trump, president as of Monday, why did he do this? And I think the answer to those questions informs our conversation this morning. This administration is clearly making its own calls on these appointments and agendas. And Donald Trump is not a traditional Republican with party platform principles. So we can't just cut and paste from prior Republican talking points to predict the direction that this is all going to go. That said, we also know that he's not going to be an extreme liberal on employment-related matters either. And we know that so many of these goals of the Biden administration are not going to survive even the first week of Donald Trump's presidency this time. We know that Trump's first term established a conservative Supreme Court majority. And so while we would like, for everyone to understand that, every single word we're about to say could prove wrong because we have entered what I believe is the golden age of who the hell knows. It is just really difficult to predict how this is going to go, given the way that the country has changed, the way the presidential elections have changed, the way that party platforms and the distinction between parties has changed over the last, let's call it 8 years. That said, I think we're pretty confident about most of the things that we're going to talk to you about. We anticipate that it's going to go this way. So let's start out with some context. Some of this is going to become clear in a few weeks or maybe just a few days, but some of it won't. You just heard the board appointments and the cases that were decided during the Biden administration are going to take some time to change, and we're going to talk about that in just a few minutes. But one of the things that I want us all to understand is it's going to be really hard to get anything done. The margins in the House of Representatives and the Senate are pretty slim. Trump struggled to get too much done in 2017, and his margins in both houses of Congress were even wider then. We have seen in recent months, in the last couple of years, with the Republican majority in the House of Representatives, that they struggle to even agree with each other at times. So the simple fact is that when it comes to the task of governing, it's much easier to align against a president to hold a party together, to say no to everything, than it is to get everyone in the margin and the majority to agree on some sort of affirmative, action by the body. And then, as I just mentioned, the Supreme Court is already very conservative, and it's likely the preferred path for many issues that matter to Donald Trump. And there's even a reasonable chance that that conservative majority could expand over the next term. If you look at some of the ages, we have two. Obviously, the oldest two are very conservative Supreme Court justices historically, that Donald Trump would have an opportunity to replace with younger people and longer tenures. But we also have Sonia Sotomayor, who's 70, who, if she were to retire or become otherwise unable to serve, then the Republican Party and or Donald Trump's own personal platform would have an opportunity to insert someone into that position to expand the majority that exists right now. All right, so what are some other appointments that matter besides those that we've discussed? We talked about Lori Chavez Derrimer. We're going to talk about her a little bit more as we get into the labor portion of our section. For a lot of us who do, especially at Burr and Forman, and anyone on this call is familiar with what we do here at Burr and Forman, we're heavily involved in traditional labor. We care very deeply about who is serving on the National Labor Relations Board and how that is going to change over the next 4 years. There are a lot of political issues that are going to impact the National Labor Relations Board. The General Counsel is a critical role. The General Counsel that has served for the past 4 years has been extremely progressive in the way that she has interpreted the NLRA. We anticipate that a lot of the memos that she issued will be rescinded pretty quickly after President Trump appoints a General Counsel to the board. We also know that Commissioner McFerrin was not renominated as anticipated at the end of the year last year. And so there's going to be a quicker flip to the board constitution than there has been in the past. So it may be a little bit more quickly that we see some of these very, very union-friendly principles that are rolled back when the board flips after President Trump's inauguration on Monday. In fact, what we saw is that when President Biden took office 4 years ago, the very first thing he did, I don't know if it's the very first thing, but it was the same day he was inaugurated, he fired the General Counsel of the National Labor Relations Board and appointed a new one. We would kind of anticipate that that's what's going to happen again. But we just don't know what it's going to look like because, again, the appointment of Lori Chavez Derrimer indicates more of a union-friendly approach from this administration than what we have seen from Republicans in the past. Andrea Lucas is expected to fill the role of the chair of the EEOC. She's the only Republican commissioner at this point, and we're going to talk a little bit more about her policy principles as we get into the presentation. OSHA is also unannounced at this time, but we anticipate an appointment that is going to roll back a few critical issues that arose during the Biden administration. Bailey's going to tell you about that. And then for the FTC, Andrew Ferguson has emerged as the nominee to chair the Federal Trade Commission. And this is important. The FTC, as we're going to talk about in a few minutes, has made some dramatic attempts in the last 4 years to change the way that business operates. Most importantly, the FTC sought to ban non-competes across the board. And it was enjoined. The regulations that were issued were enjoined. But it's interesting, again, as sort of more of a populist administration rather than a traditional Republican administration. We're going to talk about it in a second. J.D. Vance actually came out and said that the only person he believed that was effective during the Biden administration was the FTC commissioner. And there is a sympathy toward some of the ideas, the principles, the policies that the FTC was following. Andrew Ferguson is much more establishment. He's current commissioner. He's the former counsel to Mitch McConnell, who is probably, if you're going to talk about what an establishment Republican looks like, I think it would look exactly like Mitch McConnell. So, that is an indication that maybe, on some issues, we're going to be a little bit more traditional. But these are the appointments. These are the people who are going to lead the agenda for the Trump administration over the next 4 years. Some is still kind of up in the air, but we can see that it's a mixed bag. There's some that's a little bit more establishment and anticipated Republican principles, some much more populist in nature. So as we go into the next slide, I'm going to let Bailey start talking to you about some of the particular laws that we're going to expect to change and how they're going to change over the next 4 years. Take it away, Bailey.
All right. Good morning, everybody. Again, thank you for being here to witness my debut. I hope it goes well. We'll see. Bryance will be mad if it doesn't. So we're going to start with the Department of Labor. And I guess the biggest thing about that is Lori Chavez-DeRemer, again, as Bryance said, the one-term Republican from Oregon. Her biggest feature, what she's well known for, is her co-sponsoring of the PRO Act, her pro-union legislation and support from labor unions like the Teamsters. Her father, I believe, was a member of the Teamsters. So that kind of throws the Department of Labor predictions in kind of an unpredictable direction. But before we move on to some of the policy stuff, Bryance, did you want to say anything further about her?
Yeah, I mean, the labor secretary nominee is probably not as directly, day to day as relevant as the National Labor Relations Board General Counsel for traditional labor issues. So her support for labor unions will be somewhat tempered by, that layer of administration. But, someone who has this mindset, who appears to be very union friendly in her principles, can impact a lot of other things, as Bailey's about to get into: the Fair Labor Standards Act, the audit investigatory role of the Department of Labor, and then just setting kind of policy agenda across the board. That's where she has a lot of influence, and it frankly just came as a huge shock that someone who co-sponsored the PRO Act, and for those of you who have been around for a while with Burr and Foreman, you probably remember morning shows that I did, 4 years ago, talking about the next administration and the most liberal bill that had ever been proposed in this particular, area of the law. And when I say ever, I mean ever, dating back before the National Labor Relations Act was implemented. So, someone who supported that bill as the Republican nominee for labor secretary, that ought to tell us something. It tells us a little bit about what we can expect from the next 4 years. Go ahead, Bailey.
All right. So first up is this independent contractor standard. So under the Biden administration, the Labor Department used this economic realities test. It had 6 equal factors that created a lot of leeway to classify workers as employees and apply some employee protections. However, under Trump's past administration, they focused way more on these 2 central or core factors of just control over the work and profit opportunity for the worker. And focusing on those, you could see a lot more workers classified as independent contractors. And so you can likely expect a return to this kind of Trump era core factors test or some new standard where you would see a few more independent contractors. And in the box, you'll see kind of an outline of how that test works.
Yeah, and I would encourage you all, especially on this independent contractor analysis, to default to the idea that everyone's an employee unless it's pretty clear. Even with the new Trump standard, it's going to be, really still remain hard to establish someone as an independent contractor under this test. And there's just too much risk, if we miss on that, especially with a large group of employees. I can't tell you how many collective actions I've handled under the Fair Labor Standards Act asserting minimum wage claims overtime claims on behalf of a class. And when we got them, we've got them misclassified, and it's a lot of people. That can be some pretty significant exposure pretty quickly. So while this is going to be much more business friendly under the Trump administration, because I I feel certain that he's going to go back to what he did before on these core factors. It's still difficult to establish a worker as an independent contractor if they're doing what you tell them to do every day. If they're coming to work and working with one of your supervisors and that supervisor's directing the work and telling them what to do, and they're working side by side with others that have similar roles, that's probably an employee. And we don't want to let this more business friendly test encourage us to go too far with that analysis.
And speaking of the Fair Labor Standards Act, so the Biden administration raised the FLSA salary exemption threshold, as I'm sure a lot of you know. I think it's been talked about on the show before too. So as of July 1st of last year, that was raised to $844 a week, and it was supposed to raise again about 2 weeks ago, to $1,128 per week. But then a Texas federal district court struck down these increases, returning that threshold back to what it was set at under the Trump administration previously, which is $684 a week. You may see that raise again during the next 4 years, but not to the degree proposed by the Biden administration.
If some of you out there are saying, "Wait a minute, I've seen this slide before," this is deja vu that I'm having right now. I promise you that it's literally a new issue. It's just exactly the same as the one that occurred 8 years ago. The last time we talked about this, I had a lot less gray in this beard when we had this conversation, but it is eerily similar to what happened at the end of the Obama administration, where we had an increase to the minimum salary threshold, and that was enjoined by a Texas federal district court that prevented the implementation of that threshold. And then the Trump administration came in and did not pursue the appeal, which would have happened under the Obama administration, and let it die. But what we saw, a year or so later in the Trump administration was an increase to the minimum salary threshold. It just wasn't to the extent that the Obama administration proposed. In fact, the Obama administration's proposal back 8 years ago was higher than the one that the Biden administration is proposing now. So it was a more significant increase that was being proposed then. Probably going to happen again. I mean, I would assume at some point that this Trump administration would recognize that the minimum salary threshold needs to increase and try to do it more marginally, more incrementally, rather than one big jump that is more of a burden, is more of an impact on employers. But like we say every time we talk about this issue, the salary exemption threshold is it's pretty objective, right? We can look at that and know if we are paying people properly to meet that threshold. It's really important as we talk about this issue to remember that it's more important to be auditing the duties test under these exemption analyses. Are they performing? Are they using independent discretion and judgment in the exercise of their duties to satisfy the administrative exemption? Are they supervising 2 or more employees? Are they making decisions that impact, firing, hiring, compensation? Are those being given weight when they're recommended? It's really important to just continually audit those issues, because the exemption that we use to pay people on a salary basis is the subject of litigation all the time. We're constantly defending collective actions that are based on this use of the salary exemption. So always pay attention to that, but know that we did get some relief when the Texas federal court enjoined this, and we're gonna, just need to be aware, stay tuned for what the Trump administration might do in the next year or so.
So we also have some interesting campaign promises that emerged kind of later in the general election season. So Trump proposed no tax on tips, which Vice President Harris also hopped on board with. So there's a little bit of bipartisan support there. And then there's an additional proposal for no tax on overtime, which I do believe had some nonpartisan or bipartisan support, but a little bit less so. But there are also several state laws, such as in Alabama, that have implemented these for state income taxes. And so you may see a little bit of caution, see how those work out in the states before that's pursued as much. But those are quite interesting.
Yeah, I was looking at some newsletters that I get, as a lawyer, and just yesterday afternoon, I saw that Ted Cruz has already introduced a bill to eliminate the tax on tips. So, they're intending to honor these campaign promises. And the reality, of course, is that Democrats aren't likely to oppose them because they're just too easy. The win is too easy for both parties. It sounds great. And, with respect to tips, I mean, let's be honest, historically, when we used cash a lot more, and nobody paying tax on tips anyway, because they just put it in their pocket and you never reported it. It's a little bit harder in the era of the credit card and the, tap to pay sort of systems. It's probably not as big a deal. But when you think through the unintended consequences of no tax on overtime, it raises some interesting questions, and especially for those of us that are constantly dealing with the threat of unions, attempting to ensure that we don't have them in our workplaces. If there is no tax on overtime, the obvious incentive for the employer is to schedule more overtime. For a while, employees are going to love that. They're making more money. They're not paying tax on the hours that they're working over 40. But there is, sort of a slippery slope with that issue that will lead to too much overtime creates morale issues. It creates problems in the workplace. And those are the sorts of problems. In every campaign that we've ever been involved in, excessive overtime, unscheduled overtime becomes an issue. And so, we have to think about what the sort of, it's an easy win for the politician, but how are we going to manage that with our workforce? Because what we don't need to do, if this becomes the law of the land, is to begin to schedule people for 50, 60 hours a week because we don't have to pay tax on that time. Because that's going to lead to, the more serious issues that are difficult to solve, that create an unhappy workforce, that potentially lead to third-party involvement in the relationship to try to solve some of those problems. So let's just pay attention to that. The issue is not as simple as it seems. And so we want to kind of, pay attention as we go through the next 4 years.
So next up is OSHA. So with the previous administration in OSHA, they saw a decreased number of investigators and a corresponding then decreased number in investigations. You'll probably see something like that again. There was also kind of an increased focus on compliance assistance rather than like emphasis programs and press releases and just penalties in general. And you're likely to see this time around an end to some recent regulations like the walk around rule. The electronic record keeping requirement keeps going back and forth between, I think it was Bush and then Obama and then Trump and then Biden. It's going to Trump again, and we're going to get rid of it again. And then this heat safety proposed rule as well. Again, compliance assistance over penalties, less press releases like shaming employers, and a reversal again of some Biden era policies.
Yeah, and so before I jump into this OSHA slide, that we have a question, Bailey, that I wanted to answer about taxes on tips.
Okay.
The question is there an issue with Social Security benefits if tips are not taxed? It's a really great question. And I'm going to answer it in the sense that I'm going to say, I have no idea. Many of you know Logan Hinkle. He's our benefits lawyer here at Bird & Forman. I'll ask him for you after this presentation ends, but that's much more of an ERISA-related question. Probably, I think the answer is probably that there's going to be an impact on how Social Security is managed because the tips are taxed and go towards the limit for Social Security payments. So, okay. So talking about OSHA real quick, I mean, just in a big picture sense, the idea that any significant regulations are going to be modified, I don't think that's what we expect out of the Trump administration. Nobody wants to dig into the safety rules and the complex regulatory scheme that OSHA has. But what I really see as the bigger picture change is that it's going to be just more business friendly in the sense that they're not going to be looking to make examples out of employers. They're not going to be looking to impose unnecessary and extreme excessive penalties for minor events. They're not going to be looking to call someone a severe violator or a repeat violator where we're talking about issues that are minor and insignificant. So, those are the things that we anticipate really as a bigger picture issue with OSHA. Another question too from Rob, we pay overtime for 8 hours in a day and 40 hours in a week. But the Alabama tax exemption doesn't recognize overtime for 8 hours in a day. So, and that causes issues with determining the tax rate. I feel absolutely certain that the federal rules will be the same because the federal rules don't acknowledge overtime for 8 hours in a day. That's almost a California exclusive kind of mindset where you have to pay overtime if somebody works 10 hours, for example, but not 40 hours in a week. The federal rules will almost certainly be the same. And like Rob notes, that's going to cause issues with determining the tax rate. Hopefully all of those things will be better clarified in a federal law if we get one than in Alabama, which just sort of threw it out there and said, good luck, guys. But, and maybe it'll even be good that it would probably replace the Alabama law. And, we would have much more of federal guidance over how to administer that. But it is something that we want to pay attention to.
Yeah. And then moving to the EEOC, as Bryance said previously, Andrea Lucas likely to become the next chairwoman. Some things about her: she often critiques the EEOC for its use and encouragement of DEI programs, which is similar to some other Trump nominees and Trump officials. And she advocates for limiting the scope of the Pregnant Workers Fairness Act. I think, that's a quote there that you can see kind of speaking about how she believes it's kind of conflated multiple issues under the word pregnant worker. And then Project 2025, to the extent that you want to credit it, reflects on kind of what she said about the PWFA and DEI trainings. It also states that the Trump administration should work towards eliminating the EEO-1 data collection and stop including sexual orientation, gender identity, transgender status as underneath the word sex and sex discrimination in those discrimination prohibiting statutes.
We're probably going to get a Supreme Court decision about that issue pretty soon, and that'll help clarify where we're headed, the direction that we're headed with that particular issue. It's pretty rare that that's going to impact an employer. I mean, it comes up. I've had issues like that, questions about it over the years, but it's relatively rare. Bigger picture, one of the good and bad things about the EEOC, and in particular the chairwoman and the person that's driving the agenda and policy, is that the authority is so much more limited at the EEOC. They can offer guidance and interpret regs and issue Q&As and all kinds of things like that. But courts rarely credit them. They may agree, but they don't defer to the EEOC's regs as frequently as what we see with administrative law judges deferring to the general counsel, or to the board deferring to the general counsel. So while Ms. Lucas is, going to have some applicability with respect to how the EEOC processes EEOC charge, issues cause findings, makes conclusions with respect to these kinds of issues, for the most part, I can tell you that I barely care what the EEOC thinks about one of our EEOC charges. We don't cooperate all that much, and it's mainly because there's either going to be a federal lawsuit filed or there's not. The EEOC doesn't have any actual authority to impose penalties. It can file lawsuits. It can represent the charging party, but even that's relatively rare. So what we look to the EEOC for is the climate and the culture that the administration is attempting to present to the public. And so what we know with Andrea Lucas is that she's got a very conservative mindset, particularly with respect to things like sexual orientation, gender identity, transgender status. DEI has become a very polarizing issue in the country. And so we know that the culture that she's going to create is going to be, 180 degrees is the easiest way to say it from what we've seen over the past 4 years.
So moving to the NLRB, which is one of the big ones. So there's going to be some difficulty, I think, predicting what's going to happen here. Again, as Bryance mentioned, with Lori Chavez DeRemer, kind of shows an interesting direction. But so currently, as it stands, the NLRB has 2 Democratic appointed members. You can see when their terms expire there, and 1 Republican appointed, and then 2 vacancies. Obviously, President Trump will move to fill those vacancies as quickly as possible and create a 3-2 Republican majority. And then Jennifer Abruzzo is the general counsel. And again, as Bryance mentioned, she is expected to be removed from that position quite quickly, if not on Monday, then maybe Tuesday next week.
And I was talking to Marcel DeBruge, I don't know, last week sometime, and he had actually heard Ms. Abruzzo speak recently since the election. I think it was in early December. And she expects to be removed on the day of her inauguration. It's not like this will come as some sort of shock, but that this would probably be the most important thing that the new administration could do to change the dynamics of the board, because Ms. Abruzzo has been extremely aggressive in how she interprets the National Labor Relations Act. Yeah, Bailey, I'm kind of stepping on your thunder a little bit here, but some of these general counsel memos were the most progressive, extreme that we've seen, and those we would expect to be ascended. Go through some of those, Bailey, and let's talk a little bit about it.
Yeah, I mean, we have 4 listed here. So this employee surveillance memo, creating this rebuttable presumption of unlawful activity. If a reasonable employee would refuse to exercise their rights, which is a little waffly. Expanding remedies, instructing regions to pursue the full panoply of remedies, including front pay as part of any settlement, injunctive relief, asking for aggressive seeking of injunctions, and these confidentiality and non-disparagement provisions as well, enforcing prohibitions on those types of agreements.
And that's a few of the big ones, and there are more. I mean, for example, the captive audience meeting memo that she issued at the beginning of her service when she became the general counsel has recently been adopted by the board, and in an opinion issued that makes it unlawful to hold captive audience meetings. That's going to go away. I mean, I feel pretty confident in saying that will likely go away when the board has its first opportunity to go back to the old rule. There are a lot of things that the general counsel has done. For example, she's expanded the interpretation of the NLRA to believe she has, or the board has, authority over non-competes and can outlaw a non-compete on the basis that it infringes on protected concerted rights. But all of these, the Stericycle decision that forced us all to make expensive edits to our handbooks. Yeah, sorry, Bailey. Again, I'm stealing your thunder. But all of these sorts of recent decisions that the board issued during the Biden era result from memos that were they originally began as Jennifer Abruzzo memos. So these are some of the board decisions that will likely be overturned. Go through those. These are all really important, Bailey.
Yeah, now I'll get to these before Bryance jumps on them anymore. So you have CIMEX permitting bargaining orders during the for unfair labor practices occurring during the critical period, just that last period before an election, between an election petition and the actual election. The Starbucks decision, which is a really tough restriction on employer speech about the impact of unionization on the employer-employee relationship. This recent Amazon decision banning captive audience meetings, which came from an Abruzzo memo, Stericycle, as Bryance said, and this Atlanta Opera using a new standard again for independent contractors.
So think about the ways that a lot of you have participated in our positive labor relations training, our rapid response training when it comes to traditional labor, if a union shows up, what do we do? How do we respond? And some of the strategies and the tactics that we recommend and that we've used with lots and lots of clients over multiple decades that are specifically targeted by some of these cases. They are specifically targeted by some of these cases because they work. And because, lawyers like us have advised clients to utilize these tactics to educate and inform employees. Okay. So things like this, restricting employer speech about the impact of unionization, what that means is, historically we've said, if you bring a union into the employment relationship, then you have given up the ability of an employee to affect their personal terms and conditions of employment by discussions or negotiations with their leadership, with their supervisor, with their manager. And the board said, you can't tell them that it's unlawful to tell them that it will impact that relationship, even though it is categorically true. So, that came out in November of 2024. Why did it come out in November of 2024? Because there was an anticipation there's going to be a new administration. And they wanted to get that under the wire. So now it's going to require a new board case to overturn that decision, and it will be overturned. I already mentioned banning captive audience meetings. A captive audience meeting is nothing more than the employer exercising its right as an employer to control whether or not an employee attends a meeting. And in those meetings, we give them information. We provide information about what unionization means, the cost of it. The board has said you cannot require someone to come to that meeting. Again, we think that it goes well too far beyond the restriction of employer speech, and that it'll be overturned. All of these, with a Republican majority on the board, will be eventually overturned. And so, it is significant, but it's also interesting, the timing. The timing of it is going to be more of a challenge, as Bailey mentioned, because it just takes a little time to get a new board, and then it takes a little bit of time to get those appropriate cases before the board that will then reverse the decisions that have been made. But that's something that we do anticipate. If we talk about what President Trump's new agenda will be, even though it is union friendly, it is not going to be union friendly in the details. We don't anticipate that it's going to be union friendly when it comes to whether or not someone can have a captive audience meeting, because that restricts employers' speech. It prevents them from directing the work of the employee. Those are the kind of things that we would anticipate will be changed regardless of whether there is a nod towards labor during this administration.
And we'll jump to this Project 2025 proposals, again, to the extent that you credited. So there's the joint employer standard that they would like to see, I guess, contracted towards just direct and immediate control. And then these worker management and employee involvement organizations that would kind of, I guess, loosen the restrictions on what is employer-controlled unions or employer-dominated unions. And then it proposed eliminating card check recognition, opting instead for secret ballots as the exclusive means to recognize a union, and then the elimination of the contract bar, which would allow employees to decertify their union within the first 3 years of signing a contract.
You'll recall that candidate Trump, during the campaign, aggressively denied that he had any idea about Project 2025 or what proposals existed within it or the impact that it was going to have on his administration if he were elected. President-elect Trump has begun to adopt some of these proposals without specific reference to Project 2025, but in a way that lets you know that's going to be a heavy piece of the agenda. And some of these are pretty logical, things that we've espoused for years, are just, simple fairness in the employer-employee relationship. The joint employer standard is a pretty benign issue out of all of these, but it's one that we would expect is going to move a little bit. The idea of worker manager, employee involvement organizations, a lot of you already have those, where you have safety committees, or you have committees that are set up to maintain the pulse of the morale in the workplace, to just keep an eye on what's going on, to inform management about what the employees need, what they're looking for, but in a more formalized way where, they're encouraging these cooperative, almost European style workers' councils, rather than the American traditional union that's an adversarial relationship. That's the fundamental difference, is that in Europe and in some of the Asian countries, unions mean something different because they're much more collaborative in nature. And here, the act was designed to be adversarial. So it's a very different process. And this Project 2025 proposal would move it in that direction. Card check recognition is a big deal. We've got competitors, peers of our clients around the country who are allowing unions into their workplace on card check recognition, sweetheart deals with the union, which means that employees that don't want a union don't even get to vote on it. And Project 2025 would say you can't recognize a union via card check, but only through secret ballot. And, for the most part, employers would greatly prefer that employees have the opportunity to go cast a secret ballot to decide whether they want a union or not. And then the contract bar, again, finally, is a really big deal. It'll be the most difficult one to reverse because it's encoded, directly within the act, but that would be to allow employees to decertify within the first 3 years. As it stands right now, you can't decertify a union once a contract has been established until that contract expires. Most contracts are for at least 3 years. And so employees don't have the ability to say, this is not working for us, we want out. We don't want to be represented by the union anymore. Not even allowed to do that until the contract comes to its expiration date. And this proposal would say they can do it at any point. Really at any point is what it's saying, just to eliminate the contract bar altogether. And it can be decertified at any point within the process.
And then lastly, we will move to the FTC, which we talked about briefly before. The main issue here is ending the non-compete agreement ban, and then poaching agreements, non-poaching agreements as well. The Biden FTC chair, Lena Khan, pursued this aggressively, but then President Trump's pick for the FTC job, Andrew Ferguson, who we mentioned, is likely going to bring an end to those bans. There was some talk again with J.D. Vance praising Lena Khan about what kind of that meant, what the scope of that was, and it seems like a lot of the praise was focused on kind of the regulation of big tech, and you can see that in Trump's nomination of Ferguson, saying he has a proven record of standing up to big tech censorship, and Ferguson announcing himself that he would end big tech's vendetta against competition and free speech. So it does seem like we will see an end to those non-compete agreement bans, and then some continued big tech regulation.
So this is interesting to me, simply because I think there are competing interests here. J.D. Vance in particular has a long-standing, antipathy towards big tech. He's gone after it a lot of times. I mean, Trump obviously has been after big tech, and in particular the big media companies. But, sort of the competing interest here is there is no group that uses non-competes more than big tech. And so will the non-compete ban go away entirely, or will it be modified by this new administration that has it out for big tech? Again, who use that tactic, that tool, more than any other industry. And again, I mean, it's interesting that J.D. Vance specifically said Lena Khan is one of the people who's doing a pretty good job. The reason he said that is because she was going after the monopoly, the consolidation, venture capital, private equity, all of those things she was going after in the consolidation of these big tech companies. But how far does that extend? I mean, does it extend to these regulations on employment contracts? Obviously, no poaching agreements is fairly bipartisan. That's been something that's been around for a long time. But non-competes are tools that every business that has any sort of trade secrets or confidential information used for high-level employees. Is there going to be a modification to those regulations that limit it to a certain, I don't know, salary threshold or level of knowledge? Does the employee have to have access to trade secrets to be subject to these potential non-competes? Most businesses would say, look, confidentiality agreements are great. Trade secrets bars are great. But if they go work for my competitor, they're going to deliver the information that they learned from me, the trade secrets. There's no way to prevent it. That piece of paper that has the confidentiality agreement on it isn't going to do much good. I got to keep them out of there. And that's the reason that these non-competes exist. So, it'll be fascinating to see how these competing interests merge, what Andrew Ferguson is going to bring in terms of his own personal philosophy that, as I mentioned at the outset, is very establishment. It's, very traditional. The traditional establishment view of this would be that businesses ought to have a right to enter into agreements with their employees to prevent them from going to work for a competitor for a period of time. That's the business mindset when it comes to these issues. So, with respect to the FTC, I think it's still kind of up in the air, the direction that this is going to head, and we're going to have to keep our attention tuned to what could potentially happen on issues like employment contracts, all of the things that surround that, non-competes, non-solicitation, confidentiality, no poaching agreements, those sorts of things. So stay tuned.
And so we are open for questions. I think we're going to stick around for a few minutes. If anyone has anything, I think there's some sort of chat feature or something.
Yeah. So, again, I'll close out with saying we really appreciate you guys attending. I know this is an issue that isn't as practical. A lot of the morning shows that we do, you take notes and you get the presentations, you get the slides, and you implement those. You think about new handbook policies, or you think about new ways to approach a particular problem. This is more philosophical. This is much more theoretical. But I think it's important for us all to think about these issues because it helps us consider how to be prepared, the ways in which we want to prepare for the next year to 2 years. So, again, if you have further questions that come up about, what do I need to do? What can my business do to be prepared for this new administration? Please give us a call, and we're happy to talk through those issues with you. If you do want the slide, I don't know how much practical benefit it would provide, but if you do want the slides, let us know. We'll get those out to you.
The slides are great, Bryance. Don't say anything about the slides.
They're great. They're just not practical. They don't have write this policy this way, in the way that some of our past shows have done. But yes, Bailey, fantastic job in your debut performance. I appreciate all your help. Thanks everyone for attending. I don't see any new questions that we haven't. Oh, wait, yeah, hold on. Nope, just great job, Bailey. Okay.
Thanks.
Yeah, and Rob making a joke that I talk too much, which is fairly common, Bailey. First presentation or 50th, it'll probably be the same problem when you present with me. Thanks everyone for attending. And if you have any questions, just feel free to email us directly, and we'll talk to you next time.
Thank you all.